So I'd like to thank everybody for joining Thompson Hine's Coffee Chat series today. My name is Mark Miner, and I am a senior counsel in Thompson Hine's Investment Management Practice Group. So excited to have joining me today Denise Alfieri, Managing Director at Hine Compliance Consulting, LLC. She has worked in the securities industry for over 25 years and has a strong background in investment advisor regulatory compliance. We are working quite a bit with Hine, and I couldn't be more excited. Our topic today: the New York Attorney General recently adopted regulatory amendments to its anti-fraud law known as the Martin Act. These amendments have modernized blue sky filing requirements for securities sold or offered in New York or from or within New York, using the exemptions available under Reg D of the Securities Act of 1933, and created new investment advisor representative requirements. In today's session, we will examine how these amendments affect the notice filings process for issuers and the role the New York AG assumes in their implementation and enforcement. If you have any questions while we are speaking today, we encourage you to join in the discussion by using the Q&A box on your control panel. We'll try to address your questions in turn, although we will also leave time at the end of our discussion to get to as many questions as we can. And if we can't get to any particular question, we promise that we will follow up afterwards to make sure that everybody's questions are answered. So with that, let's get started. Good morning, Denise. How are you?
Good. How are you? Good morning.
I'm doing well. I'd like to start out with just a brief description of what we're really looking at with all these changes here in the modernization. I'd like to provide just a brief overview. As some of you may know, on December 1st, the New York AG announced the modernization to streamline its securities filings so that they will better align with current federal requirements, and also to create electronic filing capabilities, which is an effort that's been ongoing for a long time. The modernization of the rules also created some new obligations for investment advisors that I think everyone in the space really needs to know. So through some of these revisions, the Attorney General classifies federal covered investment company securities, federal Reg D covered securities, and federal Tier 2 securities, and the dealers thereof. For almost all of the provisions, I understand that there was maybe one hiccup. Requirements came online and were effective as of February 1st. So let me ask you, in the work that you do in serving largely private fund interests, what do you think have been the biggest changes for your clients?
I think basically just the clarification, right, of the requirements. So before there was, the argument that the Martin Act was, applied to securities offered to the public. And it also preempted federal Regulation D requirements because it was 15 days before first sale. So I think it was almost welcomed to have them more aligned with the SEC Reg D requirements, and simplify that process by also being available in the electronic filing depository, as we call EFD, in lieu of having to do the Form 99 filing, which anybody who's done that knows that it's a prescribed filing. You have the Form 99, the consent to service, the offering documents, you have the cover letter, you had to send them 3 different places, you had hard copy checks, knowing like the process. So I think it was a welcome change.
So let me back up for a minute, because that was a mouthful. For those of you who are on the line who practice quite frequently, you'll know that there is, or has been, a wrinkle for some years that was unique to New York, the infamous, or now infamous, Form 99, which, in addition to filings that virtually all other states, accepted in one filing in a singular format, and accepted electronically, was the Form 99, which was duplicative in some ways, but also had its own process. Will you just take a minute to describe for the listeners what additional hurdles the 499 presented, because the elimination of having to supply it, I think, is significant.
Yeah, I mean, the form was extensive in terms where it would ask about the offering. You had to have a wet signature on that, you know, and then again, the packet itself was prescribed. So you had to follow the instructions to a T. So there was a cover page and it had to be specific to how the New York state wanted it. And then you had to have the Form 99 underneath that. You had your offering documents. If you submitted any of that paperwork out of order or incomplete, they would retain the check and send the paperwork back again. So again, it was just such an administrative process. And then you had consent to service that went to another address. You had the continuance of a notice filing that went to another address. So it was a three-step process and a very administrative.
Anybody that's had to do that knows full well that it can be cumbersome. So in full disclosure, I was formerly the bureau chief of investor protection in New York. And so I guess I was responsible for meeting out some of that difficulty and justice for a few years. And there were issues that were always coming to your office, funneled up through different departments. This particular department is registrations. And one of the most frequent complaints that we had during my tenure there in leading the bureau was please fix electronic filing capability, and please try to align your onboarding process for funds to eliminate Form 99. Now, I came along at a time when we were working on Dodd-Frank passage and Dodd-Frank implementation. And so if you're old enough to have been practicing, then you'll know that represented some changes. New York had always had its version of bad boy provisions that it felt were not necessarily captured. But a lot of the changes following Dodd-Frank eliminated those. And so I think there was additional pressure to take that and a suite of other issues to Albany as part of its modernization. And so I'm glad they finally got that done. Quite frankly, I think it makes for greater efficiencies on both sides. Now, Denise, the New York AG has taken the position that its amendments provide adequate guidance for the changes, that they're clear. There was a set of Q&As and some back and forth during the commentary period. But we know that many market participants will say that the questions are not altogether clear, and that there are still important questions that linger. So what are the types of questions that you were getting most about clarification in the modernization of the regs?
Sure. So I think the most common was, what do I do now? So I have an existing offering. It's ongoing. I took the position before that, the Martin Act didn't apply or a preempted federal, so I hadn't filed in the state before. And so now what do I do? And so our recommendations have been, if you're getting a new LP in your fund in the state of New York, you should go ahead and make a filing in the EFD system, and you should file cumulative. So we did reach out to the state. We did ask for some clarification on this. As you're probably aware, they gave us the response that our recommendation made sense, but that's sort of all they would provide us. So we have been making that recommendation. And cumulative being, so you had someone in your fund back to 2014, that's your date of first sale. So you should report it cumulative, the total offering amount, and we have taken that position. We have submitted those filings. Again, we asked the state, will you assess late fees, or take any kind of orders or actions against those filers? Again, they said they weren't aware of any intent, but that was as far as they would go with that response. And so we have submitted filings, and we haven't seen any actions or follow-ups or inquiries since we've submitted those.
So that's excellent advice. I think we've heard some echoes of some of that with some of our clients to when you start the clock. Let me ask the other end that life cycle, what is the advice if the PE fund is no longer fundraising?
Yeah, so that's kind of a firm decision. There was some comments from the state of New York in the proposed, which they indicated that they felt like Regulation Ds were still offerings to the public, right? There's that area there where they didn't agree that even though the SEC took the position that these were privately placed offerings, they didn't necessarily agree with that. So you really have to kind of assess whether or not you do want to go and retroactively report on those LPs within that fund through the EFD system. And then if you have an active Form 99, you should be doing your renewals, as long as the fund is active. So when you go to do your renewals going forward, you would do those within the EFD system as well.
I think that we tend to get questions around those changes in the definition to the public. Also, there are many states who have tried to address or have been addressing the issue of solicitors, finders, and dealers. New York took an effort, I think, to try to address some of this. So specifically for the federally covered Reg D dealers, would you say that the regs impose new filing requirements?
Not necessarily. In my mind, it aligns with the SEC Form D process. Is that where you're going, or?
Yes.
Okay. Yep. So in my mind, to me, it harmonizes it, right? I mean, it makes it just such a simpler, more streamlined process.
Right. I think they certainly tried to bring it more in line with what was already there, and not further veer off to the new system. And I think the same would go for Reg A. They also address those in the Reg Tier 2 offerings. Are there any new requirements worth mentioning specifically for Reg A?
I would mention that there are requirements, and this applies to the Form D offerings too. So there are requirements for both the Tier 2 and the Form D filers. If you amend those filings with the SEC, the state of New York expects you to file those amendments with the state within 30 days of those changes. So even though your filings are good for 4 years before they need to be renewed, you will have ongoing requirements to make amendments to those anytime you file your amendments with the state. So it's kind of counterintuitive, really, because your Form D is going to be amended every year, right, with the SEC. So you're basically going to be submitting your Form D to the state of New York every year. You'll pay a $30 amendment fee, I believe it is, and that should be, submitted within the 30 days after you submit that Form D.
And you also have to do that concurrent with the other filing. That's interesting. So are there other states that you're aware of that have that request?
Yes, there's a few. One that pops up right away is Louisiana. So, but there are a few, yes, that have those requirements.
What should practitioners be expecting in way of fees? Have the modernization of the rules changed any fee structures?
Nope. So the fees stay the same. They're $300 to $1,200. $1,200 is an offering over $500,000. And so most fall within that. But keep in mind, too, that seems hefty, but that's a 4-year. So that's, broken out $300 per year.
Okay, great. So for those who are in this space, we've covered a few things. I know we really only have 30 minutes. Hine has studied this extensively, and while it's all very new, certainly using a consultant to help you figure out how these changes are working in real time is an excellent investment. I want to save some time for us to talk a little bit about investment advisors and the changes there. But I wanted to know if there's anything that are grand strokes about the changes on the private fund side that you think are takeaways that practitioners in the area would want to know.
Thinking it through, I think that the EFD system is going to simplify this process. I do want to caution everybody at a 4-year filing. one thing we do see with the new state of New York being 4 years is that they drop the ball. So they forget to do their renewals. So making sure that you're doing your renewals on time and getting those processed. And then just making sure that you're staying abreast, of any changes to your blue sky requirements. So there is no longer, within the guidance too, I noted that there's no Form 99 filings accepted post February of this year. So everything's to be switched over to the EFD. But if you have an active Form 99, it's good until 2024.
Well, at least there's that. Right. So again, if there are any questions or topics that weren't covered, please feel free to throw them up in the chat or follow up with us with questions, and we'll try to get to those. I'd like to discuss a little bit of the changes relating to investment advisors. So those of you who practice in this area may be aware that for many, many years, the industry has been explaining to its clients that many explain to their clients that the New York Attorney General's office does not have examination authority or regulation over investment advisor representatives. That's not really true. I guess I'll go into a little detail about that. But it is worth noting that one of the seminal changes related to this recent modernization is a new registration requirement for investment advisor representatives. In most states, there is the regulation of investment advisor representatives requires that if you fit the definition of an investment advisor representatives and you are operating in that state, that you have to file as an individual. That was never a requirement in New York. In most states, there is a de minimis requirement, often having five or more clients. But while you were talking to your clients about the states in which they intended to operate, even if you had a tickler system for them to add additional states, the standing advice for New York was that there was no investment advisor representative registration requirement. With this modernization, that has completely changed. So what does that mean, and should it mean for practitioners in the space? Well, every state has its own unique approach and methodology and culture, right? And so here, my advice would be is that this is completely new. So the process for filing, luckily now, will follow the national process. For those of you who participate in this, it's really rather simple process. Once you are going through the system and indicating the states in which you operate, you're clicking and not clicking, and you provide information with respect to individuals who need to register in that state. And so now you'll just add New York to that process. The question that has come up is, well, now New York also has examination authority. So do I need to prepare for that? Let me answer that this way. If you read the statute carefully, New York always had examination authority. They just did not have an examination program. And this really came into a sharp focus with Dodd-Frank's implementation, particularly when the threshold for state registration jumped from 25 million to 100 million, and the SEC had a big confab with the states to figure out how they were going to handle that. Many institutions were finding that 100 million was not the huge number that it used to be. The state said that they were all prepared to take that on, unless they didn't have an examination program, in which case the regional office of the SEC, in this case the Northeast Regional Office, would continue its examination efforts with respect to that state. As you can imagine, with the size of the market in New York, maybe the SEC was anxious to give over that universe, but of course there was no program that existed and it would have represented a risk to the investing public. And so they continued with that process. So we're just now in the infancy of this new rule. I think that you would expect that for the next few years, you would still see the SEC covering this universe of investment advisors. I know that the office has thought about and considered what it would take to stand up an examination program to get people adequately trained in those processes. Now, currently, they exercise what would amount to an equivalent of an examination authority, but they do it through a subpoena power, which is a very blunt instrument for what is sometimes or should be a routine process. Members of the industry never like this as an instrument because for one, it would automatically, by definition, not be a routine examination, right? So it's already at least for cause, and by the language of the statute, it would really be tantamount to an investigation of your company that potentially could trigger a whole bunch of other requirements and notifications, maybe notifications to your insurers, and invoking lots of other things. So I think that industry is excited on one hand about having the opportunity to have the state, when there is a question across the industry or a specific entity, to be able to use this new authority. So it's very early in the process. I would say whatever your compliance program is for right now, it will be business as usual, and until the office begins to announce the rollout of its own examination program. So I think we have a few questions in the chat. So one question is, has New York been sending any notices to the investment advisor representative it knows of to register, or is it all on the IAR to register? I don't know the exact answer to that. I believe from information that I have heard and conversations with staff that there is no affirmative notification that an investment advisor representative is responsible, as it is under the statute, to know whether or not it is acting in the state of New York. And the notice filing requirement that is always on the individual representative, it continues to be on the representative. And I think, this is my guess, based on experience, that if you call and ask them if you qualify, they would direct you to the statute, right? Yeah. I would say this: if you have any activity in the state and you're unsure, I would say register. And so there are many states that follow de minimis requirements. Your compliance officer may have a checklist for what those are, even ticklers or stop systems to prevent you from opening new client accounts in a particular state. But it is the representative's responsibility to know and understand where their clients live and reside. And so I wouldn't expect to receive a notice from them saying that you should expect to answer.
And what about solicitors? It says, what about the registration for solicitors? And then it indicates that those that supervise the solicitors should also be registered.
That's a good point. So there have been a number of efforts to try to get the definition of solicitor, referral, finder, etc. hammered down. If you read, and there are provisions about the definition of solicitation, clearly the office has captured a large, or intended to capture a large universe. It's a very broad definition. So if there are individuals who are operating in the capacity of I would say placement agent, solicitor, referrers, finders, who before treated New York differently. I would encourage you to take a look at that statute. It's definitely intended to capture that universe. Now, it also came online before there were two subsequent pronouncements, one by FINRA and one by the SEC, trying to create a narrow window of permissible finder activity. Right now, those rules are going to kind of work together. Just know that you would be subject to those rules in New York. And I certainly would encourage people who are in that space to read those rules, because it does impose a registration requirement for those individuals. So we have a few minutes left. See if there's any other questions I can read here. There's one I'm trying to pull up now. Oh, I don't know where that went. Let me try to find it. So let me just ask you a general question. I'll try to pull this question back up. In your experience, what is unique about dealing with New York?
I mean, I guess from my standpoint, my private fund clients that are in New York, we don't see a lot of exam activity, even from their SEC register, but we don't see a lot of exam activity. Also, the 5 or more clients, private fund clients, a lot of them aren't even notice filed in the state, because unless they have more than 5 private funds, they don't notice file there. So I think that's sort of the two nuances from my perspective. I can see one of the questions here. It says, do you agree with the New York Bar Association's position that the Martin Act's Form 99 requirement was preempted by NYAG prior to the recently enacted rule changes?
Well, that's a loaded question.
It's a loaded question.
I will say, because I was the administrator of Form 99, I thought that NYSMIA still allowed for the questions of the Form 99. I thought it was a fair question after the bad boy provisions came online, and whether or not there was any area that was not preempted by that was one that deserved an examination. And while it's still an open question, I believed then that there was a distinction between the requests that were being made under Form 99, even though some of them were rather technical and there was a lot of duplication. But I did not believe that it was preempted as a category by NYSMIA. That being said, the practical impact of trying to protect the investing public made a lot of sense to revisit what was the most useful document to collect or rely on, and to eliminate unnecessary and duplicative information when all the other features that the Form 99 were meant to capture were largely being captured by the new system. So I can say that I'm glad that they did revisit it. That issue has been to Albany, which is the state capital, many times, including when I was there. I'll just say that luckily last year that suite of reforms got changed. So I'm happy about that. I think we're at about time, and I want to thank everybody for taking the opportunity to spend a little time with us on this issue. If there are any questions that have come up that we have been unable to answer here, we'll make sure that someone gets back to you. And our next coffee chat will be Wednesday, June 16th, and my colleague Parker Bridgeport will be discussing the key elements of value at risk, VAR, and 3 methods of calculating potential loss that could incur an investing portfolio. So to register for this or future coffee chats, please visit our events page at Thompson Hine's website, and we encourage you to visit our library to peruse any prior webinar that we've had. Again, I want to thank everybody for their attendance today. Denise, I want to thank you for sharing your wonderful feedback. When the webinar ends, you will be asked, everyone, to take a little survey and provide some feedback. We'd love to hear from you. Again, thanks everybody, and it's been a great coffee.